Okay, so once again, good afternoon, everyone. And to discuss with us a detail about the legal rights and responsibilities, the laws governing the workplace, let us all welcome Madam Meng Chian. Go ahead, Madam. Take it away.
So good afternoon, classmates. Good afternoon, Dean. So I am going to present to you the legal rights and responsibilities, laws governing the workplace. Wait lang. Nag-move po ba yung presentation ko?
Yes, ma'am. Okay po.
So, for the laws governing the workplace, we have the Labor Code of the Philippines. It is the primary or main source of employment law in our country. So the legal code that determines all employment practices and labor relations in the Philippines. This is to help protect employees and employers, ensuring that that neither is subject to unfair treatment or exploitation. So the Labor Code of the Philippines provides the guidance of our rights as employees. So it was enacted on the Labor Day, year 1974, by the former President Ferdinand E. Marcos. So it is supplemented by numerous employment-related legislations, decisions, and rulings from the Supreme Court and administrative issuances from the Department of Labor and Employment. So, who are the workers protected by the employment law? So, the employees protected by the employment law are the regular employees, the project employees, seasonal employees, casual or temporary employees. We have also the fixed term employees, and of course, the probationary employees. So, for the regular employees, they are the one engaged to perform activities which are usually necessary or desirable in the usual business or trade of the employer. So they enjoy security of tenure and all the protections afforded by law. For the project employees naman, they are the one employed fixed for a specific project or undertaking, the completion of termination of which has been determined at the time employee is engaged, and thus the period of engagement is coterminous with the project. So they also enjoy security of tenure for the duration of the project only. So for the seasonal employees, those are the one perform work that is seasonal in nature and are employed only for the duration of a season. For our casual or temporary employee, those who are engaged to perform a job, work, or service which is merely incidental to the business of the employer or only for a definite period made known to the employee at the time of engagement. So they are entitled to most statutory benefits except retirement pay and service incentive leave pay. So for the fixed term employees, this is not common and are not expressly recognized in the labor code. So jurisprudence recognizes their validity under specific circumstances. They are entitled to contractual benefits and enjoy security of tenure for the duration of the contract. And lastly, for the probationary employees, those who are made to go on a trial period before regularization. So, yung I've experienced this kasi permanent ko lang last November 2020. So, nag-undergo kami ng probationary period for 6 months as required by the civil service. So, they enjoy the probationary employees enjoy security of tenure also during the probationary period and may not be dismissed except for just or authorized cause or when they fail to qualify as regular employees. So probationary employment shall not exceed 6 months. So these are the workers' basic rights. We have the equal work opportunities for all. So this one, dinidiscourage na yung discrimination. We have the security of tenure, work days and work hours, weekly rest day, wage and wage-related benefits. We have the payment of wages, employment of children, safe working conditions, right to self-organization and collective bargaining or yung tinatawag nila na nagkakaroon ng union. So for the equal work opportunities for all, the state shall protect labor, promote full employment, provide equal work opportunity regardless of your gender, your race, or creed, and regulate employee-employer relations. So male and female employees are entitled to compensation for work of equal value and to equal access to promotion and training opportunities. So discrimination against female employees is unlawful. So in general, it is unlawful to discriminate with respect to terms and conditions of employment on account of whether it will be your sex, your age, your married status, pregnant status, solo parent status, disability, mental health condition, ethnicity, actual perceived or suspected HIV status, having tuberculosis, having hepatitis, having cancer, or being cancer survivor, which is considered that you are already a PWD and the union membership. So the Magna Carta of Women or the Republic Act number 9710 as amended prohibits discrimination against women and expressly imposes liability for damages on the person directly responsible for such discrimination. For your age naman, the Anti-Age Discrimination in Employment Act or the Republic Act number 10911 prohibits discrimination on account of age and imposes penalties for violation of the act. For the Magna Carta for persons with disability, or the Republic Act number 7277 as amended provides that a qualified employee with disability shall be subject to the same terms and conditions of employment as a qualified able-bodied person. Another one is the Solo Parents Welfare Act or the Republic Act number 8972. It prohibits an employer from discriminating against any solo parent employee with respect to the terms and conditions of employment on account of the employee being a solo parent. In terms naman sa race mo, the Indigenous Peoples' Rights Act or the RA Act number 8371, it prohibits discrimination against indigenous cultural communities or indigenous people with respect to recruitment and conditions of employment on account of their descent. We have also the Anti-Sexual Harassment Act or the RA number 7877. It prohibits sexual harassment in the workplace. We have also the Mental Health Act or the RA 11036, which requires employers to develop appropriate policies and programs on the mental health in the workplace. And lastly, we have the Philippine HIV and AIDS Policy Act or the RA number 11166. It prohibits the rejection of job application, termination of employment, or other discriminatory policies in hiring, provision of employment, and other related benefits to an individual solely or partially on the basis of actual, perceived, or suspected HIV status. So next is the security of tenure. So every employee shall be assured of security of tenure. No employee can be dismissed from work except for a just or authorized cause and only after due process. So just cause, it refers to any wrongdoing committed by an employee, while the authorized cause, it refers to an economic circumstances not due to the employee's fault. So later on, makikita natin kung ano yung mga just cause at saka mga authorized cause. So in authorized causes, due process means written notice of dismissal to the employee specifying the grounds at least 30 days before the date of termination. So the inability, another one is the inability of a probationary employee. So kapag hindi mo na-meet yung prescribed standards of performance made known to you at the time of hiring is also a just cause for dismissal. Sa ito na yung sasabi ko. So, yung mga just cause, it includes serious misconduct, willful disobedience, neglect of duty, fraud or willful breach of trust. We have also the commission of crime or offense against the employer and other analogous cases. For due process in cases of just cause involves the notice to employee of intent to dismiss and grounds for dismissal, opportunity for the employee to explain his or her side, and the notice of decision to dismiss. For the authorized cause, we have the introduction of labor-saving devices, redundancy, retrenchment to prevent losses. So, like nung last year, sa kasagsagan ng pandemic, so may mga nagsarang mga company, so nagkaroon ng retrenchment. So maraming mga empleyado ang natanggal. And we have also the closure or cessation of business. So number 3, basic rights of employees is the work days and work hours. So work day refers to any day during which an employee is regularly required to work. So work hours refer to the time an employee renders actual work or is required to be on duty or to be at a prescribed workplace. So the normal hours of work in a day is 8 hours. This includes breaks or rest period that is less than 1 hour, but exceeds meal periods which shall not be less than 1 hour. So an employee must be paid for his wages for all hours work if all or any part of his or of the regular work hours falls between 10 p.m. to 6 p.m. So nagkakaroon sila ng they are entitled for a night shift pay or yung tinatawag na night differential. Kapag nag-exceed naman ng 8 days, they are entitled for an overtime pay. So, weekly rest days. So, a day off of 24 consecutive hours after 6 days of work should be scheduled by the employer upon consultation with the workers. So, wage and wage-related benefits. So, wage is the amount paid to an employee in exchange for a task, piece of work or service rendered to an employer. This includes the overtime, night differential, rest day, holiday, and 13th month pay. So, payment of wages. So, paano nga ba mababayaran ng isang empleyado? So, wages should be paid directly to the employee in cash, legal tender, or through a bank. So, wages shall be given not less than once every 2 weeks or twice within a month with at an interval not exceeding 16 days. So employment of children. The minimum employment age in the Philippines is 15 years. So any worker that is below 15 years old should be directly under the sole responsibility of his or her parents or guardians, provided that the work does not interfere with the child's schooling or normal development. No person below 18 years of age can be employed in hazardous or deleterious undertaking. So, safe working conditions. So, employers must provide workers with every kind of on-the-job protection against injury, sickness, or death through safe and healthful working conditions. It means that the workers shall be assured of effective protection against against the danger of injury, sickness, or death through safe and wait lang, and working conditions. So, say jobs may be hazardous or highly hazardous. So, hazardous jobs are those which expose the employee to dangerous environment elements, including contaminants, radiation, fire, poisonous substance, biological agents and explosives, or dangerous processes or equipment, including construction, mining, quarrying, blasting, mechanized farming, and operating heavy equipment. Thus, the worker is titled to be provided by the employer with appropriate seats, lighting and ventilation, adequate passageways, exits, and firefighting equipment, separate facilities for men and women, or separate lavatories, appropriate safety devices like protective gears, masks, helmets, safety boots, coats, or first aid kits. Or sa mga medical employees natin, they were provided PPEs to protect themselves. We have medicines, medical supplies or first aid kits, free medical and dental services and facilities. Next is the rights to self-organization and collective bargaining. So the right to self-organization is the right of every worker, free of any interference from the employer or from government, to form or join any legitimate workers' organization, association, or union of his or her own choice. So except those classified as managerial or confidential employees, all employees may form or join unions for purposes of collective bargaining and other legitimate concerted activities. So an employee is eligible for membership in an appropriate union on the first day of his or her employment. So collective bargaining involves two parties. It is the representative of the employer and union duly authorized by the majority of the employees within a bargaining unit called exclusive bargaining agent. So collective bargaining is a process where the two parties agree to fix and administer terms and conditions of employment which must not be below the minimum standard fixed by law, and to set mechanism for resolving employee grievances. So collective bargaining results in a contract called a collective bargaining agreement. So next are the employees' leave rights or employees' leave benefits. We have the sick leave. The sick leave shall be used in case of your or your dependent's illness. Next is the vacation leave. It shall be used if you would like to take a respite from your work. Next is the forced or the mandatory leave. So if you have at least 10 days vacation leave credits, you shall be required to go on vacation leave whether consecutively or intermittently for 5 working days annually. This leave shall be automatically forfeited at the end of the year if it is not used. So the special privilege leave. So after you have rendered at least 6 months of government service, you may enjoy a special privilege leave to mark personal milestones and or attend to uh, filial and domestic responsibilities for a maximum of 3 days in a given year. So for the maternity leave, before it was just 60 days maternity leave. Pero ngayon it was already amended, naging 105 days na. So maternity leave under RA 8282 as amended by RA 11210 shall be granted to female employees in every instance of pregnancy, irrespective of its frequency, for a period of 105 calendar days. Paternity leave under RA 8187 shall be granted to every married male employee for a maximum of 7 working days when his legitimate spouse with whom he is cohabitating has delivered a child or suffered a miscarriage. For the parental leave for solo parents, RA 8972, it shall be availed of by solo parents as defined under RA 8972 for a maximum of 7 working days. The rehabilitation leave may be availed for a maximum of 6 months due to job-related injuries. We have also 10 days leave for victims of violence against women and their children under RA 9262. We have the special leave for women under RA 9710. It shall be used after a surgery due to gynecological disorders for a maximum of 2 months. And also the employees have the benefit or rights for their study leave and special emergency. We also have the special emergency leave. So other compensation, allowances, and benefits. So we have the step increment every year na nakadepende sa step mo or sa salary grade mo. We have yung pera, uniform or clothing allowance, representation and transportation allowance or yung sinasabi natin sa government na rata. We have also the year-end bonus and cash gift, productivity incentive benefit, overtime pay, night shift pay. We have also the hazard duty pay, subsistence and laundry allowance or the SALA, and the anniversary bonus kapag may agency na milestone. We have also the collective negotiation agreement or CNA incentive. We have travel allowance, terminal leave benefit, and monetization of leave credits. So next is the data protection and employee privacy. So RA 10173 or otherwise known as the Data Privacy Act of 2012 is an act protecting individual personal information in information and communication system in the government and the private sector, creating for this purpose a National Privacy Commission and for other purposes. So the data protection and employee privacy, the employer's ability to process, referring to any operation or set of operations performed upon data such as collection of your personal information, recording, organization, storage, updating or modifying, retrieval, consultation, use, consolidation, blocking, erasure, or destruction of data is restricted. The data subjects consent or yung mga employee or data subjects are yung mga employee their consent is required to perform any act of data processing, including the transfer of that data to other countries. So next is the court practice and procedures. So court or tribunals that have jurisdiction to hear employment related complaints. So for us na government employees, we have the Civil Service Commission and the Office of the Ombudsman. We also have the National Labor Relations Commission, the Bureau of Labor Relations, and the National Conciliation and Mediation Board. So, procedure applied to employment-related complaints is yung tinatawag natin na conciliation mediation. It is a mode of dispute settlement that brings together two disputing parties to negotiate and settle their differences. So, it is a process of rational and orderly discussion of differences between the parties to a dispute under the guidance of a conciliator and mediator. So that would for all, and thank you for listening.
Okay, so thank you very much. Actually, this in the Philippine setting, no, especially right now, no, majority of the people, especially at the age of 40 or 45, even they are working for how many years in private sector, they are looking forward actually to transfer in a public sector. Specifically when it comes to yung sinasabi nila ng mga plantilla position, some benefits, and so on. Actually, the most challenging part at present when it comes to human resource in public and private is that maybe when it comes to the application process, medyo advanced ng konti ang private. No? They could cater or application through online, full online, no? Unlike in private public sector, medyo hindi pa lahat ng agency nakasabay sa ganung situation. Okay, so again, when it comes to the law, no, still the same in public and private sector. But in government, no, ang dami kasing mga bonus kung ano-anong bonus. Like dun sa mga maliliit lang na company sa private, talagang 13-month lang. Minsan walang bonus. Kanina ang dami sinasabi ni Madam Menchi, no, na mga kung ano-anong allowance, no? Sa government, mayroon pa kayong tinatawag na hazardous kapag medyo delikado yung lugar or yung, pero sa private wala nang mga ganun-ganon, no? So yun siguro ang advantage. At saka iba talaga pag sa government, no? Even I know I'm already 47 but I'm looking forward to work in a public sector na before I end my career, no, as an IT practitioner at the same time business, na. So thank you Madam Menchi for your presentation and good afternoon.